1 year ago this Saturday, the nation lost a legal titan when Supreme Court Justice Ruth Bader Ginsburg died. I'm Andrew Seidel, the Director of Strategic Response at the Freedom from Religion Foundation, and I'm here in Free Thought Hall, the headquarters of FFRF. And we've got a lot of great free thought art here at Free Thought Hall, including an atheist in Foxholes monument outside in the garden, and our latest addition, a bust of the notorious RBG. This bust was created by world-renowned sculptor and friend of FFRF, Zenos Frudakis. Zenos has also sculpted FFRF's Forward Award and the Clarence Darrow Award, which is modeled off of the statue that we put up in front of the Ray County Courthouse in Dayton, Tennessee, the site of the famous Scopes monkey trial. Of all the amazing art in this building, this one is special to me. I'm an attorney who has dedicated my career to separating state and church, to defending that wall of separation. And there was no greater defender of that wall than Ruth Bader Ginsburg. We all saw what happened after her death, the unseemly rush to fill her seat with an unworthy successor. We've seen how the packed court has changed course on religious freedom and reproductive justice. But today we're going to look back and remember the legacy of Ruth Bader Ginsburg. We're not live, so we're not going to be able to take your questions. This is our show from last year, where Rebecca Markert, FFRF's legal director, remembers the legacy of Ruth Bader Ginsburg.
Welcome to FFRF's Ask an Atheist. I'm Rebecca Markert, Legal Director at the Freedom from Religion Foundation. It's been a tough week for us constitutional lawyers and civil rights advocates. On Friday, we lost the small but fierce Ruth Bader Ginsburg. Her death quickly became overshadowed by the debate on her replacement. It felt to many like we didn't get a chance to actually mourn her loss. So today, FFRF wanted to slow down and take the time to pay tribute to this stalwart friend of state-church separation. Today's particularly fitting as her memorial services begin in Washington, D.C. To discuss her legacy, I'm going to be joined by our fellow secular litigators and friends, Nick Little, Vice President and General Counsel at the Center for Inquiry, and by Allison Gill, Vice President in Legal and Policy at American Atheists. As always, we will be taking questions at the end of the show, so if you have any, please leave them in the comments here on Facebook or email askanatheist@ffrf.org. So it's really hard to distill Ruth Bader Ginsburg's life down to a short bio. There's so much about her that's incredible. I'm sure you've heard many stories about her over the last 5 days. She, of course, was one of 9 women admitted to Harvard Law School back in the 1950s. She actually graduated from Columbia Law School when she transferred there her 3rd year and earned an honorary degree from Harvard back, I think, in 2011. She famously led a campaign in litigation for equal rights for women and men in the law. She worked for the ACLU, was a law professor, and then appointed to be a federal judge on the Federal Court of Appeals for the District of Columbia. Eventually, RBG was the second woman, only the second woman, to be appointed to the U.S. Supreme Court. She was appointed in 1993 by President Bill Clinton and was confirmed by the Senate by a vote of 96-3, which hardly seems possible these days. We're going to show you a brief clip from an interview with Ruth Bader Ginsburg with the BBC.
I'm optimistic long run. I was a great man. Once said that the true symbol of the United States is not the bald eagle, it is the pendulum. And when the pendulum swings too far in one direction, it will go back. We are not experiencing the best of times. but there's reason to hope that we will see a better day. Our legislature, which is the first branch of government, is right now not functioning. But I can think back to 1993, the year that President Clinton nominated me for a vacancy on the Supreme Court. I had spent 10 years of my life litigating gender discrimination cases. I was one of 4 general counsel to the American Civil Liberties Union. And yet, the vote to confirm me was 96-3. No one raised a question about my affiliation with the American Civil Liberties Union. That kind of rapport doesn't exist now. But my dream is that we will get back to it. One day, I think it will take strong people from both parties to say, let's get together and work for the good of the country. When I became a Supreme Court justice, there were 6 women in the Senate. Now there are 20. I was the second woman on the Supreme Court, and when Justice O'Connor left, I was all alone. Now I have 2 colleagues, Justice Sonia Sotomayor and Justice Helena Kagan. People ask me, well, when do you think there will be enough? I say, well, when there are 9. And people are aghast. We've had 9 men for most of the country's history, and no one thought that there was anything wrong with that.
So I like so much about that clip. I like that she focuses on hope and that she brought up the "when there are 9" quote that has been so famously recirculated, especially this last week. I'm actually wearing my "when there are 9" pin today in her honor. Of course, many of the tributes over the last week have focused, rightly so, on her work for women's rights. But she fought for equality for all of us, even non-believers and the non-religious. And she was an icon for us when it came to religious liberty issues, especially when we look at the separation of church and state. She really believed that in order for us to have true religious liberty, our government needed to be free from religion. During her 27 years on the court, she demonstrated that she was a champion of state-church separation. Today, we're going to take a look at some of the cases that showed us just how much of a friend she was to our movement. And I'm excited to be joined by our lawyer friends from our coalition sister organizations, CFI and American Atheists. Welcome, Nick and Allison.
Thank you.
Thanks.
We have really spent the last few years building up a great coalition with these partner organizations. And normally, if we were not living in a pandemic, we would get together a little more in person in Washington, D.C. So I'm missing that this year, and I'm excited that we can at least Skype you guys in for this. Over the years, Ruth Bader Ginsburg wrote a number of opinions and dissents on cases touching on religious liberty. Almost right out of the gate, she signaled where she stood on Establishment Clause cases. She dissented in the Panett case, which involved a display of a large Latin cross that was actually sponsored by the Ku Klux Klan on the State House grounds in Ohio. And she said in that dissent that if the aim of the Establishment Clause was to uncouple religion and government, that this cross could not be permitted. And she held on to that throughout her almost 30 years on the bench. In what we commonly refer to among our secular litigators group as the Bladensburg cross case, she really showcased what a friend she was to state-church separation. This was actually probably the last dissent that she wrote that focused mainly on Establishment Clause issues. Nick, do you want to just remind our viewers what Bladensburg Cross was about?
Yeah. The town of Bladensburg in Maryland, it's a DC suburb. It's incredibly busy traffic-wise, just like all DC suburbs. And on a circle in one of the busiest parts of town, there stands a war memorial, a memorial to soldiers who died in the First World War. And that memorial is a 40-foot tall concrete Latin cross, as blatant a symbol of Christianity as I think exists anywhere in the world. It was established, it was originally put up by the American Legion, a private organization, but it is on state-owned property, and it is maintained at state expense, at taxpayers' expense. So when the American Humanist Association sued that this was an Establishment Clause violation, this had decades of precedent behind it supporting it. And is possibly an indication of how far we have moved away from the understanding of the Establishment Clause of people like Justice Ginsburg, that this case managed to be a loss. And the Supreme Court ruled in what I can only describe as just intellectual blindness that this 40-foot Christian cross on state property, maintained at state expense, was not a symbol of religion. It was instead a memorial to the dead, which Justice Ginsburg and the Jewish veterans of the Great War probably disputed that they could be memorialized by a Christian cross.
Exactly. And, this case was decided, I believe the breakdown was 7-2, with Ginsburg and Sotomayor being in the dissent. And Justice Ginsburg actually read the dissent from the bench. Allison, can you tell us a little bit why that would be really significant?
Sure. Well, that indicates a higher, trying to indicate to the public that this is something that's especially of concern, that it's a break from Supreme Court tradition in a big enough way that they want to highlight it besides just writing a dissent. So most cases, most dissents are not read from the bench. And in doing so, she's indicating, well, this is a significant break from previous law. People should pay attention to it. And actually, it got more media attention because of that.
Yeah, it was very, very significant. We do have a couple of quotes that I would like to share with our viewers, just because the dissent was so remarkable and really did show just how strongly she believed in the separation of church and state. The first quote, she really is affirming what the First Amendment means, and what the Establishment Clause in particular means. She writes, "This barrier protects the integrity of individual conscience in religious matters. It guards against the anguish, hardship, and bitter strife that can occur when the government weighs in on one side of the religious debate. And while the union of government and religion tends to destroy government and to degrade religion, separating the two preserves the legitimacy of each." She also was concerned, and we'll probably talk about this a little bit later, about the court's increasingly startling trend to privilege religion, particularly Christianity, over all other religions and non-religion. So another quote that kind of speaks to that is when she wrote in Bladensburg Dissent, "By maintaining the peace cross on a public highway, the Commission elevates Christianity over other faiths and religion over non-religion. Memorializing the service of American soldiers is an admirable and unquestionably secular objective. But the Commission does not serve that objective by displaying a symbol that bears a starkly sectarian message." And finally, she says what we all know. When there is a religious iconography on public property, that confers endorsement of that particular religion by the government, and that is inappropriate and unconstitutional. So she writes, finally, "As I see it, when a cross is displayed on public property, the government may be presumed to endorse its religious content. The venue is surely associated with the state. The symbol and its meaning are just as surely associated exclusively with Christianity. It is certainly not common for property owners to open up their property to monuments that convey a message with which they do not wish to be associated. To non-Christians, nearly 30% of the population of the United States, the state's choice to display the cross on public buildings or spaces conveys a message of exclusion. It tells them they are outsiders and not full members of the political community. So it was an incredibly fabulous dissent, definitely a voice that is going to be missed. Nick, I was particularly impressed with the memorial that you wrote for Center for Inquiry just last week or over the weekend. And in your blog, May Her Memory Be a Blessing on the Loss of Ruth Bader Ginsburg, you had mentioned the Espinoza case, which is another significant case from this last term. And I wanted to talk to you a little bit more about that. So what about the dissent in that case really spoke to you? And if you want to just remind the viewers what that case was about as well, that would be great.
Sure. I went back and I was looking for cases of Justice Ginsburg that particularly impacted our work. And it's very telling that there really aren't many majority opinions from Justice Ginsburg on the Establishment Clause of church-state separation. And what that shows us is that in her strong support for the non-religious and her strong support for separation of church and state, she was out of the mainstream of what the court had become. So she was very often in dissent rather than in the majority, or if she was indeed in the majority, she wasn't given the majority opinion to write. So this term we saw a lot of brutal cases up at the Supreme Court, cases that the results have just been disastrous for the secular movement generally. And perhaps the worst of these was Espinoza versus Montana. Montana had a school voucher program, and the Montana Supreme Court turned around and said, no, if you read Montana's state constitution, we're banned from giving any money to religious schools. And so we're going to rule this entire voucher program unconstitutional. Parents of kids who were going to get these vouchers sued and went all the way to the Supreme Court, which I think we can all agree it should never have gotten near the Supreme Court because nobody had standing to challenge this at the time. But then the religious conservative majority on the court ruled that not only was the Montana Constitution unconstitutional under the federal Constitution, Montana had to reimpose a program that they had gotten rid of because somehow it discriminated against religion. And that Ginsburg's dissent here is an incredibly angry piece of writing, except it's written beautifully because everything she wrote was beautiful, but you can see the anger in it. When she's turning around and saying, there is no discrimination here. You had a program, the Supreme Court ruled that program was unconstitutional, so nobody in Montana gets vouchers. Nobody who's gone to a secular private school or a religious private school. And that is what, in her mind, the free exercise clause is meant to prevent. It's meant to prevent discriminating against one religion or against religious people. And it doesn't, because nobody gets the voucher here. I think you can see in her dissent a lot of anger and a lot of disgust at certain of the new members of the Supreme Court who are twisting precedent to try and benefit religion in this kind of fashion. I saw it as actually a very angry dissent.
It definitely certainly is more and more frustrating, I mean, even for us as lawyers, to see the court move in this direction. Obviously, the last term, we've seen a lot of cases on religious liberty. We at FFRF were monitoring at least 4 at the Supreme Court this last term. There's already 2 on the docket for next term. So I definitely can feel her anger as well. And so that's why she was also just such a great friend, because she was really able, like Nick said, to be able to put this in beautiful words that really a lot of people can understand, because part of the beauty of her writing was also that it was simple and understandable by masses. Another case that I thought was significant from the last term was the Trump versus Pennsylvania case, which we commonly refer to as the Little Sisters of the Poor case. Ruth Bader Ginsburg believed that you have the right to believe whatever you want. That's appropriate. But it's limited when your belief is going to be harming others. And that idea comes out in the Little Sisters case. Allison, you are our policy wonk in the secular litigators group. So I think that you're probably best suited to discuss Little Sisters for us. Do you want to talk a little bit about that case for our viewers?
Sure, I'm happy to. So Little Sisters, it comes out of the Hobby Lobby decision several years ago, where basically out of the Affordable Care Act, there's what they call a contraceptive mandate that requires businesses to basically, if they're providing healthcare, to also cover contraception. And so in Hobby Lobby, a closely held private organization, private business, I should say, Hobby Lobby, basically said that under the Religious Freedom Restoration Act, they should be entitled to an exemption and not have to be required to provide this contraception coverage. And so the Supreme Court allowed that. Ginsburg did, dissent there as well. But then the next stage of this is when President Trump came into office. He basically carved a very, very large hole into the contraceptive mandate that says, more broadly, not just what the Supreme Court said in Hobby Lobby, that they have to, accommodate these private, closely held businesses, but basically any business, whether they're religious or not, regardless of the outcome, gets to have a exemption to the mandate if they want it. So it was a much more broad religious exemption. And so New Jersey and Pennsylvania sued and said that this is too broad. In fact, it's so broad that it actually violates the Establishment Clause because it accommodates religion in such a way that it harms third parties. And so, unfortunately, that position did not prevail at the Supreme Court. And there's a lot of regulatory issues in this case as well. It's really a matter of regulatory law and analysis of how the Trump administration should have put forth regulations and, basically how they best accommodate RFRA. But there was a great quote I think you wanted to show about her sort of position on this.
Right. This quote really just kind of explains the alarming trend that this court is privileging religion. She wrote in her dissent, in accommodating claims of religious freedom, this court has taken a balanced approach, one that does not allow the religious beliefs of some to overwhelm the rights and interests of others who do not share those beliefs. Today, for the first time, the court casts totally aside countervailing rights and interests in its zeal to secure religious rights to the nth degree.
Yeah. And I would say that comes from or references a previous opinion by Justice Ginsburg, which was the Cutter v. Wilkinson case, where she spoke about, this was a prison litigation case, where she spoke about, the ability for the government to accommodate religious expression, so long as it does not, countervail other important interests, such as the rights of third parties, or, for example, prison safety and security in prisons. So the right is not unlimited. The Establishment Clause and other important interests limit the right of the government to and religious organizations to get accommodation. And I think, this case was very concerned about that issue.
Right. Well, this is a great transition because the next question I wanted to ask of the two of you are there other cases? I highlighted these three for our show, but are there other cases that we want to talk about where she mostly dissented and really showed what a great friend she was to state-church separation and religious liberty in general?
I don't think we can have a discussion of Ginsburg and the religion clauses without going back to the case that started all of this in the modern Supreme Court time, the Hobby Lobby case. Alison mentioned it. Ginsburg's dissent in Hobby Lobby is a thing of beauty. It says everything we at CFI have been arguing about religious exemptions. That she talks about, granting Hobby Lobby the exemption for contraception. What's next? How can we stop? How can we not grant an Orthodox Jewish employer or a Muslim employer an exemption to providing vaccination insurance that covers vaccinations, or Scientologists' employers insurance that covers mental health care? This is something we have put directly in our amicus brief, and it gets so much to the heart of the issue that what is at stake here? It's the old saying of, your right to swing your fist stops at my nose, and your right to religious freedom stops when it takes things away from me. You're entitled to religious freedom. And all three of us will take cases defending that right, both for minority and majority religions. But there comes a time when we have to say no more. And Ginsburg recognized the time to say no more was when you are trying to take a burden and not remove the burden, but shift that burden onto a third party.
Yeah.
I think that's a fantastic point. And another major case I would point to is Christian Legal Society v. Martinez, which was a 2010 case where Justice Ginsburg. This is it's basically a free speech case. It also brings in a lot of religious elements, but at its core, it's also a free speech case. And so basically, this religious student group, the Christian Legal Society, sued to have to be able to be recognized by a university and still be able to discriminate and exclude members and leaders who did not agree with its religious precepts. And so Ginsburg really looked at this as a free speech issue and said that the university is allowed to have what's called all-comer policies, which means that the university is allowed to make sure that all student organizations that are recognized accept all students that want to participate. And so that's fine within the stream of the First Amendment. And I think that's really important today, especially because that right is under challenge by the Trump administration, who for example, just finalized a new rule that came out today that really attempts to say that public universities must allow student organizations to both be recognized and also to discriminate, directly contravening what CLS v. Martinez said.
And what I think is absolutely critical there is that the Christian Legal Society was allowed to discriminate. They were allowed to carry on. They just couldn't be an officially recognized organization and get money from the university if they wanted to go on discriminating. And that's what we're seeing. It's not just, the right to have beliefs. What they're claiming now is the right to hold those beliefs, which they do, but also receive taxpayer money when they're implementing their beliefs. And that's where there's a problem.
Yeah. That's right. Yeah. And Alison, just before the show, you also mentioned the Masterpiece Cake Shop case. Did you have any thoughts on her dissent in that case?
Sure. This was an important case in 2018 where basically a cake shop in Colorado who was a complaint was brought against them for civil rights discrimination because they refused to serve a cake for a wedding for a same-sex couple. And the court said, I think rather disingenuously, that there was evidence of animus against the baker and his business, because two members of the Civil Rights Commission made statements that somehow they interpreted as being hostile or evidence of animus, and also that they accepted other, the commission looked at other complaints and did not find that those to be meritorious complaints because they were, I won't get into the argument too, it's very, very specific and picayune. However, her dissent really sort of tears apart this argument that these statements had animus and that there was animosity, and also that the other complaints somehow proved that the complaint in question was targeted and was brought in bad faith. So it was really helpful to have at least one person on the court talk about how this claim was on its face false.
Yeah. So over the last 5 days since her death, there have been a lot of stories being shared on social media and on Twitter, and probably, just in your circles. But do you have a favorite story about RBG? Doesn't necessarily have to touch on state church, but if you do, I'd like to hear them.
Well, I asked her to marry me after the Hobby Lobby dissent, but other than that, I think that, to me, the great story about her I've heard recently is a forward quote, and it's after she was nominated for the Supreme Court. She received a letter from telling her that her co-students at Harvard Law School referred to her as bitch. And her response to that just is 4 words and is just so perfect. I think it sums up where she was, where we all need to be. Her response to being called bitch was better bitch than mouse.
I actually have never heard that story. That's awesome.
Yeah. And in my world of short quotes, to move 4 words to 3 words about where we need to be on this, I'll quote from the labor union activist Joe Hill, who was murdered by the government. He was framed and executed by the government. And his last 3 words, which I think are essential for when we look at where we are with Ginsburg, were don't mourn, organize. And the best way we can remember Justice Ginsburg is by doing what she did, and that's to carry on fighting for the downtrodden, for the discriminated against, for the victimized.
Absolutely. Allison, do you have any favorite stories?
I don't have a specific story, and that might be because largely I feel like many of her contributions to the court were somewhat invisible, because they involved her arguments at oral argument, her sort of focusing and inflecting the court on the important questions about where it needed to be and the influence she had there. It was her ability to speak to the other members of the Supreme Court and sort of bring them along on various issues. I think these are all incredibly critical, but they're also, like I said, largely invisible. Would we have had the good decisions we had, especially on things like LGBTQ civil rights, without Justice Ginsburg? Things like Windsor, Obergefell, the recent Bostock decision. I don't know, and I don't think so, because she was able to speak to her colleagues in such a way as to bring them along, as to unite them. And I look at the Bostock decision, for example, and that was by Justice Gorsuch. However, we've heard from behind the scenes that Justice Ginsburg and others played a really important role in sort of getting him to take this sort of textualist approach in that interpretation. So I think that many of the things that she tried to do are incredibly important, and her voice will be sorely missed.
I will have to echo a lot of that, Allison, because I think for me, one of the favorite stories that I have of her are just how she was, invisible, but quiet and hardworking. And a lot of the success that she had is just because she was this reserved, quiet person who did a lot of behind the scenes work and really put her nose to the grindstone to get things done. And one of the things that I really admire about her is actually the relationship that she had with her husband, Marty Ginsburg, and how much impact he had because of his belief and confidence in her and who she was. I think many people know that he was one of the big reasons that her name got put before Bill Clinton. And, she wasn't necessarily seeking the spotlight on a lot of these cases. She didn't become the notorious RBG until much, much later in her legal career. And so I really just admire somebody who isn't looking for the fame and the glory, is just looking to do what's right and is willing to really sit down and work hard and not need to take the glory necessarily. We do have our figure of Ruth Bader Ginsburg here in our office. It's a fun little action figure for us to play with. She is the secular saint of the studio, Bruce tells me. So, we're all lawyers here, and I might have kind of touched on it a little bit, but was there anything that she did that might have impacted your career in any way?
Wow.
It's hard.
Every time a decision came out, the first thing I looked for was what side Ginsburg was on and whether she wrote on it. It's not so much my career, but it's society in general. Abortion is still legal in the United States because of Ruth Bader Ginsburg. And I don't know what's going to happen there now. So she impacted society.
Right.
Yeah, I don't know that I really have an answer there either. I think that when I was in law school, constitutional law was always my favorite. I was one of those people that took every available constitutional law course, and so I've read a lot of her decisions over the years. At the same time, there's nothing really springing to mind as far as my career directly. So I don't have much to add there.
That's all right. I think for me, to answer this question, I think the thing that I go to is just a lot of her stories about being a working mom. I, of course, have 4 young children at home. It's been increasingly difficult working from home with 4 children during this pandemic time. And the first thing I thought of when I heard of her death on Friday night was when she was talking about the school calling her about her children during the school day, which is, of course, also during her work day, and how it happened constantly, and she was getting frustrated. And at one point, she just outright told the principal, this child has 2 parents. Why don't you call them? And I just really like that. And I feel that every time I'm getting frustrated with the amount of work that seems to fall on me as a working mom, I was always glad that, she's also in my corner in that realm as well. So, of course, we'd be remiss if we didn't mention the vacancy on the Supreme Court. President Trump is poised to announce his nomination this Saturday. Mm-hmm. We at FFRF released a statement earlier this week urging the Senate to adhere to her dying wish, which was to wait until 2021 to replace her. I believe that your organizations released similar statements. Is that correct? I know I saw something from CFI on that as well.
Yes, we did. American Atheists also released a statement, and we're about to put out an action alert today that encourages constituents to take action by reaching out to both of their senators and telling them that they should wait until a new president is installed before moving forward with the confirmation.
Well, that's fantastic. So we are also releasing action alerts all week, asking people to call their senators. Ginsburg dedicated her entire career on and off the court to providing equal protection of the laws, including for women, LGBTQ individuals, advancing justice for people of color, and preserving our democracy. She often advised, fight for the things you care about, but do it in a way that will lead others to join you. So we, these secular organizations, invite you to join us in fighting like your rights depend on it, like your country depends on it, because they do. As Ginsburg noted, real change, enduring change, happens one step at a time. So please take that step. Call both your senators to insist that they ensure people get to decide who appoints Ginsburg's replacement. Call 202-224-3121 now. Even if, especially if you think their votes are locked in, then call them again tomorrow and the day after that and every day. So we are going to take questions now from our viewers. Allison and Nick, I'm going to pull up the questions here and shoot them towards you guys and decide amongst yourselves who wants to answer them. Sure. The first question comes from Heather Johnson, who writes, how might this loss affect your organization's pending cases?
It's not good.
What's that?
It's not going to be good. It's hard to say about our cases exactly. I'm most worried, honestly, about the Fulton decision, which is one of the Supreme Court decisions that will be heard in the fall that Rebecca mentioned. It's going to be heard on November 4th. And it's an incredibly important case that will really decide whether to keep, Employment Division v. Smith or not, which is a really seminal case that protects our work. And so, I don't know if we're going to have eight members of the court decide that case, or if there'll be a new person that decides it, which will probably be even worse. So I'm most concerned about that in terms of our work.
Yeah, I mean, it's important to remember there's this big idea out there that a Supreme Court justice is either liberal or conservative, and that there's this really clear split, and that before this there was a 5-4 split on the court. On our issues, there actually wasn't. I mean, we've been losing cases at the Supreme Court 7-2. Ginsburg and Sotomayor being the only support we've been getting on a strict interpretation of the Establishment Clause. I think all of us as organizations are recognizing that we need to address the way we bring things before the courts, and that the old traditional cases of displays, sort of war memorial crosses, that those with this current court, especially after Ginsburg has left, just aren't the way to be going forward.
And, you mentioned losing the cases 7-2. I saw on Twitter, I believe it was law professor Michael Schwartzman, who is from the University of Virginia. He had just tweeted out a list of these religious liberty cases, and just next to them, 7-2, 7-2, 7-2. And what that looks like without Ruth Bader Ginsburg is 8-1, 8-1, 8-1. And I told my staff yesterday at a meeting that just feels worse than 7-2, to really have Sotomayor be the only person standing up for our rights and our movement is really, really disconcerting, and one of the reasons we do need to be ruthless and fight back right now.
But what's critical on that, if you look at the two recent abortion cases, Whole Women's Health, where Justice Kennedy was the fifth vote to defend abortion rights, and then June Medical Services after Kennedy left the court, where Chief Justice Roberts was. I do not believe Chief Justice Roberts would have moved over to support abortion rights without Ginsburg's work convincing him of that. And that's the big first case we're going to lose, is on abortion rights.
I agree with that. And I would also say that it's sort of in the opposite position we used to be in with regard to Justice Thomas. He used to be the only person with this sort of outlier voice, especially on, Establishment Clause issues, saying, for example, that this should not be incorporated in the first place. It should not pertain to anybody but Congress. And now, not only is he being joined in that position, but we're on the opposite end, where we only have one person actually standing up for the historical separation of religion and government.
So another question is from Mike Martinez, and he asks, don't we need her seat filled to prevent any deadlocked ties? Isn't that why there are an odd number of justices? So Nick, do you want to talk a little bit about what happens when we're deadlocked like this?
There's not really any tie in the judicial system, even though you can have a tie at the Supreme Court. If the Supreme Court comes to 4-4 or 3-3 or fails to find a verdict, then the previous verdict already stands. The verdict from the Court of Appeals stands. So avoiding, two answers to that. Firstly, avoiding ties isn't actually necessary because the previous opinion stands. And secondly, filling it too soon with the wrong person just creates disastrous decisions. I'd rather the Supreme Court was unable to come to any decision than was able to come to a bad decision that'll sit with us for as long as historically bad decisions like, Dred Scott, like Plessy versus Ferguson sat with us. It takes a long time to rectify a bad Supreme Court decision.
I would point to what happened when McConnell sort of blocked Merrick Garland from getting on the court. I mean, that was almost a year. How many Americans noticed? So
right.
I don't think it's a crisis. I think we can wait 2-3 months. It's not the end of the world.
Right. Well, so there's a bit of a follow-up. Heather Johnson also asked if a vacancy is left and cases are split, they will be bounced back down to where Trump has packed the courts with these extreme conservative judges. Are there considerations for that when we're filling the vacancy?
It bounces back to circuit courts where Trump has packed them with extreme conservative justices, or it stays at the Supreme Court where he has packed it with extreme conservative justices. The federal court system has become packed. It's not just Trump. It goes back beyond that. It's the policies of the Federalist Society in working to ensure that originalists in particular, their view is overrepresented on the federal courts at all levels. So I'll repeat again, it's bad if cases are being decided in the wrong way. It's worse if cases are being decided by the Supreme Court in the wrong way, because that impacts the entire country.
I agree. And, these considerations and what Nick was talking about, are the primary reason that we've taken a stance that the number of justices, especially on lower courts, I'll say especially on lower courts, and we're open to the Supreme Court too, should be increased if there's a new administration and with the new Congress, because frankly, the courts, they're not friendly to the historical understanding of the separation of religion and government. And in this environment, it's almost impossible for us to actually increase and improve the state of the law. And so we need to basically move forward. And I'll say also the federal courts are super overburdened. So it's perfectly legitimate to increase the number of justices because they need to be increased.
So that was a question by Therese Marie Elton Bajoyle. She wrote, do you think if Biden becomes president, he should increase the numbers on the Supreme Court? And I think, Allison, you kind of already answered that for us. Nick, do you have anything to say on that?
I know we as CFI don't have an official position on that.
Right.
I do think Allison makes some very valid points.
Right. So the last question we have is from William Wallace. Doesn't the Constitution say that the Supreme Court seat should be filled immediately? No. There's nothing in the Constitution that says that. Otherwise, we wouldn't have been in situations like Merrick Garland, where, Allison rightly pointed out that was almost a year that he was sitting.
And we've had
times like this, I miss Britain, where we don't have a written constitution and everything's just like, oh, it's all what has been done in past practice. But no, there's nothing about filling a seat immediately.
Right. And we've seen how much American politicians care about past practice, so I don't know if that's the right approach here. I should also note that there's been different numbers of members on the Supreme Court previously. It's not mandated anywhere.
Set to 9. That's correct.
Right. Yeah.
That's correct.
But before we break, Rebecca, I wanted to just, since you got to show off your action figure, show off my board game that I got for a Christmas gift last year.
Oh, that's awesome.
great. So I played it a few times. It's
Tell
about
me, what are the rules of that game? Like, and what's the objective?
well, it's basically it's not specifically about. I mean, it's based on Justice Ginsburg, but it's a little bit more loose. Like someone has sort of a, I don't know, ridiculous proposition, and people have to make arguments for it and vote against. It's sort of like apples to apples or a game like that in a way. But it's a lot of fun.
Well, if we are ever allowed to congregate again at the Secular Coalition for America conference, we should definitely play that. It sounds like it would be a lot of fun. I want to thank you guys so much for joining us today. It was great to see you, even if it was only via Skype. You guys are amazing advocates for our movement, and I'm lucky to be working alongside you guys. So thank you very much for being with us today.
Thanks for joining us for that look back at the life of Ruth Bader Ginsburg. We hope you'll join us again next week for another episode of FFRF's Ask an Atheist.